When you think of a contract, your immediate thought may be a dense stack of documents consisting of complex language where two parties must sign into agreement. However, this is not always the case. Today we will discuss oral contracts as we explore a case from 2011, Valley Proteins Incorporated versus Halsey Environmental Services Incorporated. Valley Proteins and Halsey Environmental Services both maintain and clean grease traps. Waffle House proposed a contract for one company to do all their grease trap services. Halsey won that contract. Some locations were not profitable, so Halsey subcontracted with Valley Proteins to service their certain locations for them. Boggs and Rosenstein are management-level employees at Valley Proteins. They met with Halsey employees to come to an agreement about the subcontract terms. Valley Proteins brought this lawsuit against Halsey Environmental Services, claiming that the defendant never paid them for their services. The defendant argues that the traps were not clean in the manner that had been agreed upon. So, what exactly was the agreement?
It appears that Boggs and Rosenstein have similar accounts of the agreement made between Halsey's employees and themselves.
Both Boggs and Rosenstein claim that they met with our client and agreed that the pump-dry method would be used with the price of service per gallon at 18 cents.
The client did email a blank subcontractor agreement. However, it was never signed by the plaintiff. Despite this, our clients noticed that the pump and return method was being used instead of the previously agreed upon pump-dry method.
Correct. Boggs claimed that he apologized and ensured that the error in the system causing the mix-up had been fixed. Yet, our client claims the problem continued and thus refused to pay Valley Proteins for their services. What makes a binding oral contract? Well, there are a few things that we must consider, one of the most important being mutual assent. Mutual assent is an agreement made by all parties involved in the contract. It requires that terms and conditions are well defined and that both parties had mutual intent to be bound by these conditions. Without mutual assent, a contract cannot be valid. The other important consideration is whether the statute of frauds is applicable. Statute of frauds requires certain agreements to be in writing. While these statutes can differ by state, there are types of agreements that are uniformly covered. These are marriage, land, executors, goods, suretyship, and year. Year being an agreement that cannot be done within 1 year of when it was made. In this case, none of the uniform requirements apply. Therefore, the contract did not need to be in writing. The agreement made by the plaintiff and defendant could have been done in a variety of ways. However, regardless of the format or complexity, if mutual assent is present, the contract is valid.
They may argue Boggs lacked authority and therefore without corporate approval there is not mutual assent.
Well, Boggs and Rosenstein have been allowed by the plaintiff to appear as agents for Valley Proteins many times before. Additionally, Rosenstein stated to us earlier that he sent an email about the deal to his supervisors and was not met with any objections.
There were clear terms expressed by our client's employees when they met with Boggs and Rosenstein. As stated before, they agreed upon a price, method, and location.
They did mention the unsigned contract that our client emailed to the defendant. Could they argue that the written agreement implied that they were not bounded by the oral agreements?
They may argue it, however, they never signed the contract that was emailed to them. Besides, their oral contract is valid. An unsigned contract does not disagree the validity of their oral agreements.
After all of the information that has been presented, you may be wondering what the ruling was. Well, the court determined there is a binding oral contract because mutual assent was present. As discussed earlier, there were clear terms agreed upon between the parties. The plaintiff's quasi-contract remedies were dismissed. Claims for promissory estoppel, quantum merit, and unjust enrichment were dismissed as well. Each of these were dismissed by the court due to the presence of a binding oral contract and the terms within said contract. So what have we learned? Contracts are not always what we may imagine. You may not have signed a piece of paper or had lawyers present. This doesn't mean you aren't bound by a valid contract. If mutual assent, a valid offer and acceptance, consideration, and capacity are present, there is a valid contract, as we saw in this case.